All right, let's see. So to kind of summarize this then, the advantages of a trust are that it does not die at the death of the settlor or grantor. The trustee or successor trustee has authority to act without court approval. The income and estate tax returns, both for the federal, at least there is no longer a state, if required, are filed by the trustee, so the heirs don't have that burden about figuring out taxes and returns and all that. And the trust terminates or continues as set forth in that trust agreement. So if you have done what's called a generation skip and your children get income for their lives, and then the actual, say it's a farm, and the actual farm then is to invest in your grandchildren, it's an easy continuum there for the trustee to keep that going, paying income, and then making that transfer upon the death of the income beneficiaries. Okay, and then a few other advantages: you avoid the cost and delays of probate. The financial information remains confidential. You don't have to file anything at the courthouse. In other words, the trust maintains control of the assets after the settlor grantor's death. You have avoidance of, you can at least have avoidance of a guardianship or conservator, because the trustee, again, is a fiduciary, and he or she can run the financial affairs of this family. And really, when you think about it, a family is nothing more than a business, just at least from the financial aspect of it. There's assets to be dealt with, there's money, there's income, there might be a small business to sell, there might be a family farm to sell or dispose of or do something with, get transferred in some way. You can take care of all that kind of thing efficiently through a trust. And then it also reduces the likelihood of a contest over asset distribution. If you've got a trust, there really isn't anything to dispute. You've got the list, it clearly says who gets what. And in a will, a lot of times people wait till literally the very last minute to execute a will, and then if you've got feuding relatives, feuding heirs, the heirs that don't get as much or don't get anything may contest the validity of the will as being, obtained by fraud or coercion, undue influence, all those kinds of things, where the trust normally doesn't have to worry about those kind of things. And especially if the trustee is someone other than the grantor or the settlor. There are a few disadvantages. I've thought of three. They require a little more time and expense to create than especially a simple will. They do not reduce income or estate tax liability at the federal level, and they can create a psychological impact and that's the biggest hurdle, is it can be a little bit of a psychological impact for the owner of the assets, especially let's say it's a farmer or a small business person who've accumulated these assets over the course of 20, 30, 40 years. There's a little bit of a psychological aspect to that is, I created this, I'm good to go, I'm going to keep this till the day I die, when it really would be best to have some transitional planning going on there that can be facilitated with the trust. And then the other things too, a couple of other things, just a couple of other points, and then I think Christian wants to visit with you about some things as well. If you are dealing with a family farm or a small business situation, you need to be, no matter what you're doing with your estate plan, you need to be concerned with liquidity. What are we going to do for cash? Because especially in a small business, you have employees, you have people that you have to pay, you have bills and things you have to pay, so you need to be concerned about liquidity. Upon my death, how are we going to do that? Is it going to be with life insurance or an annuity or cash flow from the business? But however that's going to happen, you need to give that some thought and some planning. Business valuation. Let's say you're in business with a partner, and even if the partner is a relative of yours, when you die or when that partner dies, that business valuation is going to become important, because your heirs or the partner's heirs, and again, in an LLC situation, the people aren't called partners anymore, but that's what they are to some extent. They're called managers and unit owners, but they're still much like a partner. So you have to decide, what we're going to do about business valuation, upon one of the partner's deaths, what are we going to do to cash out so that the surviving spouse of the deceased partner has, money to live on, things like that. And that goes right into the next point, which is insurance coverage. Are we going to provide for, some life insurance, through the company or the farming operation? Are we going to do that on an individual basis? What are we going to do, though, to make sure that the surviving people that are going on after our death have some income and have some money to live on? Then sources of a buyout. If you're a sole, even if you've got an LLC or a corporation, but you're the only owner, you're the sole stockholder, you're the sole unit owner, who might be out there, or how might you deal with the fact that when you pass away, you've got this valuable asset, and Christian and I were talking about this just the other day. You've got this valuable asset that now is sitting there without a manager. What are the survivors going to do to transition that property to someone else so that you realize income to support the spouse through the remainder of her life or whatever it might be? And then, of course, you also need a buy-sell agreement if there are more than one person involved, whether it's 2 or 20 or 20 or 100. You need to be looking at a buy-sell agreement which says that upon the death of one, what those remaining managers or unit owners or stockholders are going to do with that business or that farming operation, whatever it might be. So you've got those considerations to make too. And I think that would be, because I know we're trying to do this in a relatively short order, and I don't want to take all of Christian's time. If you guys have some questions, we might field those right quick, and then I'll let Christian start. Anybody have any questions about any of these things, a will, a testamentary trust within a more complex will, or a revocable trust, anything like that?
My only question is, I don't feel like I really have much, but it sounds to me like regardless I should do a trust. I mean, that would just be safer.
Well, if you've got insurance,
have insurance,
if you have a house, you got a bank account, you have a car, and probably some, I don't know how the bank works that, but you may have a 401k, you may have an IRA, you may have some CDs, you might even have some stock.
Wow,
so you start thinking you start thinking about these things, and you realize I do have a little bit of something, and I need to be the one. You need to be the one that decides where that's going to go, not the great state of Oklahoma. And so, and you're not, and as you get older, you'll accumulate more stuff. Everybody always does. So as you accumulate, you put that into the trust. Well, you're just making sure that what you have gets to the people that you really want it to get to. So yeah, I mean, even for someone that's relatively young and all that, maybe this revocable trust situation is a pretty good idea.
And then if you have a minor child at the time, and so you don't want to make them the trustee, but you want them to benefit from, or ultimately benefit from.
Yeah, and what you do on that is you state within your documents how old you want that child to be before the trust terminates and the trustee distributes the money. And if you're in a situation where the successor trustee might not be totally obvious, then you have to give that a little bit of thought. But yeah, I mean, you would want probably in a situation like that, the settlor, which would be you in that situation, would be the initial trustee, and upon your death, you'd want to have a secondary alternate trustee that would take over and keep the trust in place and going until the child reached. A lot of people do 25. Some people do a little older than that. But I think you'd want to. What we normally look at over at our firm is that 21 is probably a minimum. Some people will grouse around and talk me into 18, but I try to resist that, because at 21 they've either gone through college or they've had their first job experience and they're a little more mature. So when they get the money or the asset, whatever it may be, they're not as inclined to go buy a Corvette and blow it all at once. can't keep them on a rope forever, but you don't want them to just turn loose and go do something silly. So 25, at that point, they're usually, again, work experience for college and work and all that, and it's just a pretty good age. A little older than that, you still got these expenses of the trust going on. You may not want to do that, but you've got to decide what age. And a lot of people just think, well, how wild was I when I was 18 or 21 or whatever, 25 or whatever it might have been. You see, so or 35 or whatever it may be.
My son takes over when he's 65.
Yeah, there you go.
He gets 5% a year.
Yeah,
And then when
well,
65, he gets the ballot. That's how they're at.
and those people don't wait till 65, but they do wait into 30, 35 sometimes for sure. So.
I'm the age I used to look up to. What was I thinking? I don't know
Exactly.
anything more now than when I was 19.
Exactly. There
That's
you
scary.
go. That is scary.
Because doing a revocable trust early is a lot easier to get all your stuff together.
Right, and then it's just an
Yeah,
accounting
you don't have to
function.
have, it's easier to just, okay, I got this, and this.
And
Well,
and
and
as
then
you
you
have-
just, yeah, I was just gonna.
Yeah, and as you acquire things, trade cars, buy new houses, buy some oil and gas interest or whatever it might be.
Put the title in the trust.
You just put the title in the trust, and you add that to your Exhibit A to your trust, and you just keep marching along. And it's exactly right when the worst happens, and that's just one less thing for your heirs to have to deal with.
Which I guess is because in a will, in my will at least, I have some very specific things designated for very specific people, most
Yes.
of which been burglarized and don't exist anymore. But in a will, then you've got to do a codicil to the will in order to change that.
redo it entirely, which is
Yeah.
going to be
As opposed
add-
to a trust where you
Yeah.
would just,
add it.
you just add or change it.
Right. Yeah, the revocable trust is completely flexible in terms of amendments and all that, and it doesn't have to have the same level of formality that a will does. When we do a will, for instance, if it's just a will, I always ask people things like, have you taken any drugs today that would affect your ability to think about this? Are you under the influence of this person that's sitting next to you? Have you asked me to be, a witness to your will? Have you asked Amy Jenkins to be the note? I mean, you've got all this formality to go through. Whereas on a trust, are you ready to execute this document? Yes. Have you reviewed it? Yes. Boom, you're good to go. So it's like a contract instead of this testamentary instrument. Yeah. So really, you do have that. You've got that that aspect to it on a will. I mean, the standard to prove that you appropriately executed is much higher than with a trust. So, anybody else have any questions?
Where do you draw the line between having things such as bank accounts in the name of the trust versus things that are enumerated that are part of the trust? Like you mentioned, the vehicle. Should vehicles, the title be in the name of the trust versus an addendum that says these are items that are in the trust?
If the item is on the Exhibit A, I usually strongly suggest to the people that they put it into the trust. And what I normally do on cars in specific is someone will come in and they'll do their trust and we'll get it all squared away, and I will help them get the deeds put together to their real estate or their oil and gas or whatever it might be. Do a bill of sale on things like cattle or whatever they might have that's business-related properties. And on cars, I'll tell them, okay, you're probably going to buy another car one of these days, right? And they invariably say yes. And I say, okay, you can save that $15 on that car title. So just leave it like it is until you buy the new car. Then when you buy the new one, put it in the name of the trust. And that at that same time, then you need to talk to your insurance agent and change the insurance payment from you to your trust. And that saves you a little bit of a hassle with the car, because if you transfer the existing car and you got to go transfer the insurance and that kind of thing. Whereas if you just buy a new car and trade the old one in, you're right there dealing with that paperwork to begin with. And that's what I normally tell people. If they say, no, I'm not going to buy a new car, then we try to get it to